May I please understand? Item 30 on
31.
30. I have some difficulty in second half.
P. Roman, adjourned.
Hello, friends.
Item 1 for motion. Item 1.
None appears for a petitioner adjourned.
Item 2.
Yes, item 2. 2 weeks. Shifting.
My lord. Page number 42, my lord. 1966 voter list. This is grandfather, my lord.
No, that we understand. Last word is produce any material regarding shifting from of Juran Ali from Langlar part 95 to Bogula Mari.
We explored. There is no document as of such.
No, any material
My lord,
which may be the basis for the court to accept that there was a shifting.
I file an affidavit, my lord, through some relevant.
Mr. A.W. Aman, like a petitioner seek for adjournment to produce the relevant material as required by the order of 18/1/2020. But this is now, Mr. 8 months have gone by. 8/1 was the first order.
My lord, next time I will file it.
What will you do?
I'll file an affidavit through someone from Langla village.
No, do whatever you do.
My lord,
At least bring something so that we can go forward.
my lord. Keep the-
Item 3.
Yes, item 3. To show the petitioner is the son of Janikulla. Which material will show that the petitioner is the son of Janikulla?
Lordship, page number, Lordship. Page number, Lordship, 33, Lord.
33.
Lordship. And 34, Lordship. This is
Page number 30.
33 and 34, Lordship.
33. Holoikunda. Shahjahan Ali. 2005.
Village. Itu, Holoikunda. 85 to I say.
So, Shahjahan Ali, son of Janik of Holoikunda, who is he? Who is Shahjahan Ali, son of Janik, whose name appears in the voters list of 2005 of Holoikunda? Who is he?
He is the son of Janik. Janik and Janikullah.
We are not understanding son of. Who is he? Petitioner or father of petitioner? Or
Son. Son of Janik Lordship.
which of you? Who is the petitioner?
Sajan Ali.
So he is the petitioner,
Yes.
son of Janik of Holoikunda. How do you know that Janik is a citizen? How do you know that Janik of Holoikunda, he himself is a citizen?
Lordship, kindly turn to page number 35. Lordship.
35.
Lordship. Oh, no, sorry, Lordship.
35 is of
Well,
certificate.
Lordship, regarding wife, Lordship.
Prepare, come. Adjourn to enable the land council to examine as to as per which material Janik, father of Shahjahan of the 2005 voters list of Holoikunda, he is himself a citizen.
My lord,
Next item.
NLC. Obvious.
Item 4.
In this case, petitioner is no more, my lord.
What do you do? Satyabala Das.
Yes,
Can you close it?
applause, my lord.
Satyabala Das. Legal से आपको भाभी बोले मेरे माँ अंगद सी वजह से What should we do, Mr. Sharma?
Lordship,
What should we do? If the
If-
family wants a determination,
yes, Lord.
whether the deceased mother or wife or whoever she is a citizen,
Better to substitute Lordship. Otherwise, Lordship,
so she'll remain a declared foreigner.
yes, Lordship,
Somebody may not like it.
yes, Lordship.
Suppose the daughter is a marriageable age.
In future.
When
Lordship,
the
siblings
in-laws come to
suffer
know that the
Lordship.
mother is a declared foreigner,
Yes, Lord.
she may have problem. Lot of aspects are there. Other than sorry, you will- Amrit Lal. Why don't you implement Amrit Lal declaration particular? You are not interested, Mr. Modi?
My lord.
You want to implement them or you don't want to implement?
Satyabala has three children.
Three
my lord.
sons,
Three
Amrit
sons.
Lal, Nikhilesh and Patiklal.
Yes.
You want to implement them or you don't want to implement them?
My lord, I have to take instruction in.
It's
this regard.
stated that the petitioner Satyawala Das is no more. Mr. A. Ahmed, like other petitioner, seeks for adjournment to obtain the instruction as to whether the legal heirs of Satyawala Das intends to get
Okay.
themselves substituted in the writ petition.
Okay.
This after 4 weeks.
Item 5.
May I please, your lordship?
Petitioner to produce material which may show that Joinal Abedin of 66, Many Simla is the father of the petitioner.
Lordship, we have filed two affidavit, additional affidavit. Lordship, please come to page 31. Lordship, we have annexed voter list of Joanal bin and Gahura Khatun. That is the petitioner. The name has been reflected in the voter list of 1966, 1970, 1985, and 1989 and 2010.
And not journal abiding. In the which material will show that petitioner Johera is the daughter of Jainal Abedin?
Lots of, come to page 58.
Page number 58.
58. The name of the petitioner.
There is no
reflected in the
58 page number. You prepare yourself. The petitioner to provide the information to the court on the next returnable date as to which material would show that the petitioner Jahera Khatun is the daughter of Jainal Abedin of the 1966 voters list of village Manisimla. List again, next item.
Item 6,
Rahima Khatun, Rashid 6 further material to indicate that petition is the daughter of Siraj. Same.
We are searching, some documents are available, but I have not received yet. So sometime.
Want some adjournment. Mr. A. Rashid, this is a seeks my adjournment to provide the material as indicated in the order of 1/3/2023. But this is almost how many months now? Hmm?
4 months past.
4 months or 5 months?
8.
8 minus 3 is 5.
5 years.
August is 8, March is 3.
Managing asked me not 4 months. Anyway, time is available, but they are not cooperating so easily. That is the problem.
Then we close the petition. They are possibly not interested.
More or less, that is correct.
Then we close it.
So that is
What do you do? Why do you take the trouble of somebody
I have
else?
informed twice then, they are saying that yes, we are collecting it, we are getting it, but not yet. Last time also I informed them. Receive me, yes, they come.
But
after-
something has to be there. Na?
Yes, I- So after,
What to do?
they said after this Independence Day, they will come.
After?
This 15 August.
After 15, some auspicious.
Next this some rushes, the other buses.
Sorry.
Some bus rushes.
Now there is a Russian bus.
One bus,
Later on, it will be easier to travel.
yes, for them. Actually, their passenger of public bus. After 2 weeks, I'll evaluate if you are coming.
It's noticed that the requirement to provide the information was by the order dated 1/3/2023 and 5 months has already gone by. List on so and so specific date. Otherwise, it won't be listed for another 5 months.
item 7,
Yes, Mr. Chairman. Excellent. Means that there was an Ejahar earlier opinion whether some. February, not yet. List after 2 weeks in February. Why it is listed only now in August? August, March list after 2 weeks. February.
My lord, the document of reference. I have
So
submitted,
now what is your case? That earlier you were declared to be an Indian citizen.
my lord.
That is your case.
Yes, my lord.
But that was already taken in the earlier writ petition. And when it was taken in the earlier writ petition, it was sent back whether the two persons are one and the same.
Yes, my lord.
What is the finding of the tribunal, whether same or not?
Tribunal finding is that the both are not same person.
Not same. So then forget about it.
But my lord, my submission is that from the inquiry report itself, there is a prima facie indication that both are same person, my lord.
Anyway, let us see. We may reject it for res judicata also.
My lord, kindly.
Where is the earlier judgment? Which page is the earlier judgment?
My lord, I'll tell you.
Is it a reasoned decision?
Yes, my lord.
Page number
Page 43, my lord.
43. No. It is for he's almost to prove.
Considering the entire materials on record and discussion.
This is not a reasoned judgment.
Yes.
Considering the entire material and discussion, there is no discussion. What the tribunal state, he had submitted the following document in his support.
Yes, my lord.
Then paragraph before that, proceeded deposed that so and so and this thing.
Documents are not discussed. my lord.
Nothing is discussed. Which document, because of what reason will show you are a citizen, that is not stated. So in order to be res judicata, it must be between the same parties, number one. Now we don't know whether it is same party or different party.
Yes.
Secondly, it is not a decision because decision is always a reasoned conclusion. This is a conclusion without any reason. So res judicata is not applicable. So you prove your case independently. We'll hear it. Instead of relying upon some earlier order, you prove your case now.
May I pray some time for argument? my lord?
That's all. When the matter was heard on 1/3/2023, the petitioner raised a claim that in an earlier proceeding, in case number FT bracket 8/808/16 of the Foreigners Tribunal number 8 Gwalpara, comma, by the opinion dated opinion dated 29/12/2017, he was declared to be a foreigner. When the petitioner was referred once again before the tribunal, resulting in FT case number 901/18 in the Foreigners Tribunal number 8 Gwalpara, he was declared to be a foreigner. Being aggrieved, an earlier writ petition was instituted, taking the plea of res judicata that as he was earlier declared to be of an Indian citizen, therefore the subsequent reference is not maintainable in law. In the circumstance, the matter was remanded back to the tribunal to arrive at a conclusion as to whether the writ petitioner proceeding and the proceeding in case number FT 8/806/16 in the Foreigners Tribunal number 8 Gwalpara are one and the same person. Upon being remanded back, the order dated, which order?
Page 80, Lordship.
Page 8. The order dated 36/2022 had been passed by the Foreign Tribunal 8 Golpara in Miss case 01/2021 in FT 8/901/2018 that the proceeding in the earlier proceeding case number FT 8/806/816 and the proceeding in FT 8/901/18 are not one and the same person. Being aggrieved, this writ petition is instituted against the order dated 36/2022. No material is available before the court to arrive at any conclusion that the proceeding in FT case number FT 8/808/16 and the proceeding case number FT 8/901/18 are one and the same person. Although the petitioner was given adequate opportunity to produce any relevant material. We have also examined the earlier opinion dated 29/12/2017 as to whether the earlier opinion was a decision under the law. The question whether the earlier opinion was a decision finds relevance in as much as the petitioner is claiming the benefit of the principles of res judicata, wherein two conditions precedent are that the earlier proceeding and the later proceeding must be between the same parties, and secondly, there must be a decision in the earlier proceeding. As both the conditions precedent are not satisfied in the instant case. No, in the instant case, upon examining the opinion dated so and so, we have noticed that the tribunal merely takes note of the materials that have been produced by the petitioner, and without any reason as to how those materials indicate that he is a citizen, the tribunal, by an unreasoned order, had declared the petitioner to be a citizen. From such point of view, we are unable to accept that the earlier opinion dated so and so in FT 2016 earlier one is a decision, as both the conditions precedent, that is the earlier proceeding and the later proceeding, are between the same parties, and that there was a decision in the earlier proceeding, are not satisfied. We are unable to accept the submission of the petitioner that the present proceeding is barred by the principles of res judicata. But however, Mr. S. Alim, Land Council petitioner, seeks for an adjournment to explore as to whether any further material is available with the petitioner to discharge the burden under Section 9 of the Foreigners Act that he is not a person. For the for the purpose of exploring as to whether any further material is available, the matter is adjourned. But however, the plea of the present proceeding being barred by the res judicata had been decided as indicated above.
Highly obliged.
List on so and so.
Strike 28, 280. Item 8,
I am obliged, my lord.
My lord, in item 8, my lord,
One time.
My lord, I could not trace out my file. from the
Adjournment of prayer, Mr. Here, Signal and also petition to be listed on 21.
Any day of the next week, my lord.
21st.
Fine.
Item 9.
Nine, yes,
May I please, your lordship?
Mr. Daskit.
Sometime may be allowed, lordship,
For
to
what
find out
purpose?
some other material to establish the linkage with the petitioner with her parents, lordship.
On 21/6/2023, when the matter was listed, adjourned one was sought for on the behalf of the petitioner. Again, on 21/7/2023, it was adjourned on the behalf of Mr. M. Dasgupta and counsel petitioner. Today, again, when the matter is listed, your name,
Yes, Ali, lordship.
Mr. S. Adi, land counsel appearing for the petitioner seeks for an adjournment to explore as to whether any material is available to establish that the petitioner is not a foreigner under the Foreigners Act 1946. In view of such prayer, matter adjourned, but it is provided that no further adjournment will be granted for the same reason.
Lordship.
23rd August. Item 10.
Lord, may I please, lordship, may I, lordship? So. earlier-
Item 10
item-
has been, Mr. Counsel,
Sorry,
there's some
lordship, pardon.
discipline in a court proceeding. Item 10 has been called. You please give way to Mr. Raman.
Pardon, lordship.
Anything you have to say, you can tell the court master. Yes, Mr. Raman.
Hello. On the last occasion.
Your lordship, I have
They
received the instruction.
expired the second with sale deed, they was executed according only the registration. You rely on some sale deed,
Yes, my
which,
lord.
which page?
Page number 38,
38,
37, my lord.
37.
The translated copy. Also, I have got some voter list now.
No, date fix हो गया सर, fix हो गया. Lumai na lumai, sir mana होते हैं. Kabo mani. Lumai di ko na rin, no? Sir mana.
That was a new one. None of them. Yes, Madam Fupan, what do you say?
It's mismatch, your lordship. It is
You read? Let him read. Mr. Sharma, you also read because you are the.
Yes, lordship, it is not matching, lordship.
You do one thing. Whatever is the report, file in the former and affidavit and give him one copy, let him, whatever reply he wants to give, let him give.
Yes, sir.
Because if you have to act against him on this report, he needs an opportunity to explain.
Yes, sir.
The Deputy Commissioner Nogao, as required by the order 21/7/2023, had submitted an inquiry report as to under what circumstance the sale deed at page 38 relied upon by the writ petitioner was executed. A reading of the inquiry report makes it discernible that the dark number and patta number in respect of the sale deed do not match with that of the depicted in the sale deed. And that if the dark number and patta number as available in the official records is to be followed, they do not include either of the petitioners or the persons named in the sale deed to be pattadas. The said information may be brought on record by filing an affidavit to the extent indicated in the inquiry report. You don't have to bring anything more.
Yes.
Only what is there in the inquiry. The petitioner, if so advised, may file reply to such affidavit of the deputy commissioner. Just after 2 weeks.
Oblige.
Date did you over.
Item 11.
Yes, not to be shared.
He was here. Yes, Paul. Yes, Mr. Raman.
May please, your lordship. This is regarding your lordship, res judicata, your lordship. Res judicata, your lordship.
Rest judicata.
Earlier,
Is it a recent decision? Let us see.
page 16, your lordship.
Mr. Pine. The other day,
Yes,
you did not like it very much when he asked you to do something. Other day, another learned counsel also was almost of the same approach. Why we want to change to some extent? See, in the last case, they rely upon a sale deed. If you go by the sale deed, he has made up the case. We have to declare him to be a citizen. But we took the extra precaution of finding out whether that sale deed, it appeared to us to be something wrong with it. Ask the deputy commissioner to submit an inquiry report. Inquiry report is in your favor. So, if you adjust your approach to some extent, same thing could have been done by the tribunal also.
Yes.
When it was produced, instead of mechanically going into it and find out the difference in one spelling and one age here and there, tribunal also could have done the same thing. It's from Nagaon, deputy commissioner Nagaon only. They can also could have requested the deputy commissioner kindly inquire and give us a
Yes,
thing.
we are, my lord, after your lordship's judgment.
Uh,
that
No, is
case,
it not much easier procedure? Whatever material is produced, instead of trying to avoid it and saying that this is this, this is that, why don't you take it head on?
That's why, my lord,
It's a conclusion is,
understood.
it will go in your favor and you will do a better service to the state than otherwise.
In the meantime, my lord, we have taken this up, my lord, among the AGPs of the, my lord, tribunals. We had a meeting already, my lord. I asked them to get a, my lord, information with regard to the entire documents, whatever is published.
Whatever is document, get a report straight
Yes,
away.
get a report from SP,
See,
but that should be, my lord, confidential. That should not be.
keep it confidential.
Yes.
No one.
that might not be submitted.
Once you rely upon that document, you have to
Yes.
put it across
Yes,
to
yes,
the other
yes,
side
yes.
to give them an opportunity.
Yes.
That is
That-
the
that's-
only requirement of
yes.
law. Say, now I have asked that, find it in an affidavit, give him an opportunity. Let
Yes.
him say whatever he has to
Yes,
say.
yes.
Because otherwise you cannot act against him.
Yes.
Or unilaterally on some document. Suppose people are taking help of a voters list. That's 66 voters list, so and so person, he is my father. Instead of taking the approach that the father was 40 years in 66, so in 77, he ought to have been 51 years, but he's shown as 55 years, so I reject both. Supreme Court will heavily come against you if you adopt this procedure. Because you cannot reject the entire evidence just because of that one.
My lord, we are in
Haha.
fact instructing not to
So-
minor discrepancies if it is.
So-
there.
What you do is, why can't you send one police to the house of that person of that 66 voters list, make a verification inquiry in his house and find out. In one case, we allowed you to do this. You had not allowed, we allow in every case, but you had done it. It came out that that family says that this person is not of our family. Don't you think this is a more authentic and better approach? And that is conclusive. Once the family of X of 66 voters list, whether he is there or his sons are there or whoever are there, says that this man does not belong to our family. Our family is XYZ. These are the people and they are here. It's a best method you can adopt. Straight away, that man can be rejected because there are material to show that you are not the son of that man.
We are doing that now, my lord, at this
So-
stage. We have instructed every AGPs to take the help of the police to get the information, then place it before the tribunal. My lord, all these things. And in the meantime, my lord, if in some cases, my lord, if your lordship directs, we will file affidavit.
No, we want to file a comprehensive order. You kindly cooperate and help us in that
Yes.
to arrive at. And you also think of what best can be put.
Yes.
Now, instead of just
Going here and there.
here and there, all ultimately going here and there, what is the difficulty, you know? Some of these methods are not supported by the provisions of law. Ultimately, it will go against you. If not at this stage, at least in the next stage, it is going to go against you.
So, my lord, here also, if your lordship, my lord, directs, in some cases, we will file affidavit.
Here
Because-
also you file. Suppose you file that you notice that something drastically wrong is
Yes.
going on. Just file an affidavit, raise that plea. They are bound to answer it.
So we are discussing that issue.
A little more cooperation and little more effort, that's all.
Yes, yes, obviously.
You'll see, if you do it for 1 year, you'll see everything will be streamlined.
Yes. We are trying to do.
And
that.
you will also face less problem in the court also.
Yes. Understood.
Because why? You'll be ready with material.
Yes,
Straight away, you can stand up and say, this is my material to show that he is wrong. Your burden is discharged. And on this burden of proof never means burden of proof to my satisfaction. Until I am satisfied, you have not discharged. That principle is not available. Even if out of the 100 possible things, even if they discharge 5% or 10% also, still under the law, that is a discharge. That 5% also has to be rebutted. You can check up the Evidence Act, that's a law. And only in one nature of cases you'll find where the concept of disbelief is available, that is in a 376 case, when there is only one witness, that is the prosecutrix. There a few Supreme Court judgments are there, under what circumstance the evidence of the prosecutrix is to be disbelieved. Other than that, you will not find anywhere. every other aspect, the only situation where you can disbelieve is where collateral evidence indicates something different.
That is
So you prepare yourself for the collateral evidence. At least some. Moment you have some collateral evidence, you can always rely on your collateral evidence, say that this is unacceptable.
We'll discuss this more.
So please do it, streamline it, tell us. And in that particular matter, we are going to pass a little more comprehensive order. You,
But that is fixed today, my lord, but.
that is
Sorry, my
fixed
lord.
today?
Yes, my lord. I
Okay.
could not file the affidavit. I have sent it, my lord. I will
Okay, we'll,
take another
we'll
one.
take it up next week, doesn't
Yes.
matter. But please cooperate and you also apply your mind. Mr. Sharma, you also apply your mind. Aswena Verma also apply. Which provisions you put in your order will be more effective for everybody?
Yes.
Not just you, for everyone, for both the parties.
Okay.
This is a res judicata.
Your lordship.
Was it an opinion, earlier one?
This opinion is page 16, your lordship.
No, was it an opinion?
There is something, your lordship.
Something means
Reason opinion, your lordship.
a reasoned opinion. Let us see. Page number
Page number 16, your lordship.
16.
1-6. And the evidence appreciated in page
Just a
18.
minute. The conclusion therefore I have produced, respondent furnished 66 where the name of the parents appear. Yeah. In 1797, 79, name of the father of the respondent appears. Mr. Raman,
Lordship.
come to the last paragraph of page 18.
Lordship.
This
have-
is the conclusion. Rest everything is depiction.
Lordship.
I have perused the documents furnished, found that respondent furnished certified copy of 66 voters list,
Lordship.
where the name of the parents appear. This is the finding that the name of the parents appear.
Appear.
Why does the tribunal say that it is the parents?
Lordship.
This is the difficulty we are having in
Lordship.
accepting it.
Lordship.
So there must be a prior finding that this
Lordship.
person is the father.
Father.
But here is a presumption that he is the father.
Greatly presume that this father.
That's all. Why it is said? Because one person claims that it is so,
Lordship.
but there is no. So now we give you opportunity here also. Suppose we follow this judgment,
Lordship.
not the present one.
Lordship.
Show us by which material will show that the 66 voters list of Garaipuri, that name is not given, that person is the father.
Page 20, page 25. your lordship.
25. 25, this is 1966. Garaipuri, Mohiruddin.
Mohiruddin Sheikh.
Mohiruddin is the father.
Father. Your lordship.
So now which material will show Mohiruddin is the father?
Page 29. Your lordship.
29.
Voter list of 9.
93, village Garaipuri, same one. Mohiruddin, same Mohiruddin.
Mohiruddin.
Mohiruddin is the father. And petitioner?
And page 29. Your lordship.
What's the name of the petitioner?
Hossein Ali, Hassan, no?
Hossein or Hassan?
Hassan Ali,
Hassan.
Hassan Ali. Mohiruddin
And
and
this
Hassan
is
Ali.
for motion.
Motion, your lordship.
Mr. Sharma, we agree. But you have to produce all the intervening voters.
Lordship.
Heard Mr. P. Rahman.
Lordship.
Case 30.
What this is all. Can we do this one? No, I think there are probably 93 there are probably. I was 66 there are probably. This is a very good evidence. It will now what will remain is related to procedural and this Hassan same person. You'll also have to prove
Lordship.
that Hassem of 1993 voters
Lordship.
list and the present Hassem petitioner, they are the same person.
Lordship.
This question will leave it open.
Yes, Lordship.
You bring whatever material.
Lordship.
The Hassem of 93, he can satisfy that he may be a.
Lordship.
Case 31, Lordship.
Earlier,
I know there is some other villages.
Other
and
village.
we have noticed it.
but presently I am temporarily residing at another
Then-
village.
That question will keep it open. You'll
Open,
have to
your
prove.
lordship.
The petitioner relies on voters list of 1966 of village Gerapuri, which contains a name of Mohiruddin Sheikh, son of Ali Boxo at serial 126, whose age is shown to be 39 years. Further reliance on the voter list of 1993 of village Gerapuri, which contains a name of Mohiruddin, son of Ali Boxo at serial 331, and that of Hasem Ali, son of Mohiruddin at 333. And Mohiruddin is shown to be 65 years. The information contained in the two voters list appears to be consistent. And as the name of Hasem Ali appears with Mohiruddin in the 1993 voters list, and the name of Mohiruddin appears in the 1966 voters list, the discharge burden under section 9 may have been discharged. But further question would remain as to whether Hasem Ali of the 1993 voters list of village Gerapuri and the writ petitioner Hasem Ali are one and the same person. No material is available at present to examine the same. Accordingly, the question is kept open to be decided at the time of hearing. Further, the claim of the petitioner for res judicata by referring to an earlier opinion dated 4/4/2015 in FT case 5276/G/12 before the Foreigners Tribunal Goalpara would also be unacceptable, as the examination of the earlier opinion does not reveal that it is a decision by the tribunal. The tribunal merely, in the last paragraph of page 18, merely provides that the petitioner relies upon a voters list of 1966 of village Gerapuri, where the names of the parents of the petitioner appear, as well as a voters list of 1979, where the name of the father of the petitioner appears, but there is no conclusion as to why the tribunal was of the view that such names contained in the two voters list is the father of the petitioner. Accordingly, we propose to decide the matter afresh on the claim of the petition. But however, before, as a primary is made out, interim notice.
Both the
Call for the
record.
records. Both, that one already rejected. Why do we need that record? In this record, whatever is, we will decide it.
I looked.
Item 12. 5 September.
Yes, madam.
My dear lordship, in this case, inaction of this police, my lord, investigation of the case by the FIR dated 1/6/23, my lord, annexure 1 page 8, my lord,
Police inaction. Where is the FIR?
page 8, my lord.
Hmm. Hmm. Dictamen judgment আছে যে not accepting this FIR
No, my lord.
or they have accepted.
My lord, neither register or not any entry of this media entry, my lord.
Yes, why are you not registering?
Lordship, in my humble submission, Lordship, Supreme Court, in the case of Sakiri Basu, Lordship, in this
Sakari Basu, we know
Lordship,
that what is Sakari Basu?
Sakiri Basu, it has been stated that instead of straight away rushing to the Honorable High Courts,
So in what circumstance?
if an FIR is not registered, and even if after registration of the FIR, no proper investigation is made, in such circumstances, the remedy lies to approach the jurisdictional magistrates, Lordship. The jurisdictional magistrates. He can direct.
Suppose a factual circumstance is that your police is in collusion with the accused and therefore not registering, then
Lordship. The learned
so
case-
why can't we ask you the reason of not registering? Instead of going to rushing to Sakari Basu straight away, how does the 220 jurisdiction taken away? Suppose your police is in collusion with this accused person,
That may happen. That may happen. Lordship.
then a legal right is violated.
Lordship. Lordship, let us obtain the instruction.
And let us look at Sakari Basu, what you are relying
Lordship.
on. And I will be for Sakari Basu. No, nowadays the common objection is Sakari Basu.
Lordship.
Means as if Sakari Basu had done away with everything. Let us see what Sakari Basu said.
And it was reiterated in 2016 also. Lord.
Understand. Let us see what it is stated.
In the Sakiri Basu judgment, Lordship may come to paragraph number 11. Lordship. May I read, Lordship?
Hmm. Citizen. SP2 to us, yeah. Your 11 paragraph,
11, Lordship,
11.
11. May I read, Lordship?
No, you did not read. We have read it.
Lordship. Then thereafter, Lordship, paragraph number 24. Lordship may kindly have a look. Paragraph number 24. Five paragraphs I will be relying on.
Your review, the High Court should not encourage this practice and should ordinarily refuse.
Ordinarily.
So before going to the ordinary recourse, we'd like to know why.
Lordship. For that, Lordship, let us have the instruction.
So once you say the actual reason and that reason requires determination, we'll send it to the magistrate. Because again, that will be a question of evaluating the factual situation.
Lordship.
Then magistrate is more appropriate, where magistrate can take evidence.
Evidence.
But suppose it's a case you have absolutely no reason.
Yes.
Then why a writ court cannot? Number one,
Yes.
it is not an absolute exclusion of the jurisdiction of 226.
Absolute embargo is not there.
It's not there. Suppose there are issues that you are in collision with someone, then
Lordship.
writ court may order a inquiry by some higher police authority or by the CID. There are a number of aspects are there.
Lordship.
Give us the reason. Give us the reason.
Lordship.
This writ petition is instituted on an assertion that the petitioner submitted a FIR before the officer in charge of Hatigaon police station against the purported accused person, Rafiqul Islam Mondol. But in spite of lodging of such a FIR, no police case had been registered. Mr. R.K. Talgidar lent counsel for the respondents in the Home Department to obtain the information from the officer in charge of Hatigaon police station as to why a police case was not registered pursuant to the said FIR. Number 3, you'll have to delete. Number 3, you'll have to delete. Chairman Police Accountability Commission. Why did you make that authority a party? Did you go to the Police Accountability Commission? Have we approached the Police Accountability Commission? Where is your statement? Sorry. Where is your statement that you approached the Accountability Commission?
Lordship, paragraph number 4, Lordship, page 5. They have stated, Lordship. Petitioner submitted a complaint dated 24/6/2023 to respondent number 3, seeking appropriate action, but till today, no action has been taken by him.
What happened to that proceeding? Nothing.
Nothing, my lord.
Did you ever go to the commission again after submitting a complaint?
No, my lord.
Where is your statement that I have been repeatedly going to the commission, but the commission is not informing me anything?
No such ever been, Lordship.
You must have given one application, forgotten about it. So you forget about your application, commission also must have forgotten about it. How can you blame your commission? You guys, tell us the reason. Why?
Lordship.
List on next week.
Lordship. Obliged.
Fixed date.
Item 13. 22nd August. 22nd, 23rd August.
May it please your lordship. My lord, the petitioner father name appear in the voter list 1966, 1970,
19,
That's the-
page number
page 38 lordship.
38.
Afesuddin is my father, my lord. Page 39.
Bartari.
Bartari, my lord, village. Next, my lord, page
Bartari,
40.
60. Just a minute. Who is the father?
Father Afesuddin, my lord.
Afez.
Yes, my lord.
Afezuddin father. And who is the petitioner? Sahara.
Sahara
Which
Khatun.
material will show? Sahara, daughter of Afez.
Lordship, may kindly see page 47, lord. Is a
47.
certificate issued by Gaura of petitioner parent village, man.
What is this?
This is the Gaura certificate, madam. Gaura also examined, but
Where is the evidence of Gangura?
Lordship, may kindly see page 34, madam. And the cross motion is, my lord, page 36. My lord, tribunal himself, my lord, cross examined. And the rejection reason is that, my lord.
Forget about the rejection reason.
Lordship,
We also dismiss your petition.
Lordship.
Yes, okay. We also intend to dismiss your petition.
Lordship.
Shall I pass the order?
My lord, see, Gaura, 73 years old, my lord.
We intend to dismiss your petition.
Lordship.
So let us pass the order.
My lord, his brother also examined, my lord, elder brother.
Where is it?
Lordship, may kindly see page 32, my lord.
32. Synopsis of answers given by OP to the queries made by tribunal.
Yes, my lord.
How do you know he is a brother?
Lordship, may, can we see?
No, and personally, this is no evidence. Synopsis of answers. Synopsis answer is not an evidence. Evidence is a complete evidence.
Lordship, may kindly see page 45.
45.
Along.
Where is the farthest voters list? Page number?
My lord, page 38.
38. Okay. And now where is this Jamabandi?
Lordship, find page
45.
45. Same village. my lord.
Ramzan Ali নামক mutation হয়েছে। Ramzan Ali আগে থাকি দিছে। Mr. Sharma, Afez 66 voters list.
Voter village.
Village Bartari. Mutation shows Ramjan inherited land of Afez of Bartari. Ramjan deposes before the tribunal. Timing we accept it? Motion, right? Third, the petitioner relies upon the voters list of 1966 of village Bartari which contains the name of Afezuddin, son of Munshi Sheikh at serial 233. It is claimed that Afezuddin is the father of the petitioner. Reliance is also placed upon a Jamabandi of a plot of land at village Bartari, which contains the order of the circle officers of 5/3/1996, by which name had been mutated in favor of Ranjan Ali, son of Afezuddin, in place of Afezuddin, in respect of a plot of land at village Bartari. Ramjan Ali, son of Afezuddin, had rendered evidence before the tribunal as DW 2, stating that the petitioner Sahera Khatun is his sister as well as daughter of Afezuddin. But however, it is noticed that the evidence rendered by DW2 is not complete and only a synopsis of the same is produced before the court. Petitioner to produce the complete evidence of DW2.
I'm meantime, my lord.
Okay.
This is-
Motion. 14.
The evidence of the Gaumbura relied upon does not appear to satisfy the requirement of section 50 of the Evidence Act, and hence cannot be relied upon.
On the basis of a certain
Discarded evidence. Yes, sir.
Please, your lordship, page 20, your lordship, annexure to your lordship, there is the great grandfather of the your lordship petitioner, your lordship, that is Zubed Ali, your lordship.
Page 22.
20, your lordship, annexure to your lordship.
Zubed Ali
Is
is the great grandfather.
65, your lordship.
Now, who is the grandfather?
The grandfather, your lordship, will find at page 22, your lordship, Samed Ali. However, the great grandfather's name has
Just a
been
minute, go a little slow.
your lordship.
Village is
Tuktuki, your lordship.
Tuki. Now, who is the grandfather?
Grandfather, that is Samed Ali, your lordship, page 22, your lordship.
Grandfather. Now, who is the father?
Your lordship, father, your lordship will get at page, your lordship, 24. That is grandfather, your lordship. Grandfather Samed Ali, page 24, your lordship. Again, 1985 voter list, your lordship. Another 1985 voter list, your lordship. at
Come to
page-
the directly to your father.
Your lordship. That
85,
is
page
page
26.
26, your lordship. Muntaz Ali, your lordship. Single name voter list, your lordship.
Why he is the father? Because he is the son of Samed.
Your lordship. Your lordship.
Is the village same?
Your lordship, there is a shifting, your lordship, from.
How will you
Tuktuki to
prove? How will you
Kolopi,
prove the shifting?
Your lordship.
How will you prove that there is shifting?
Your lordship, that was your lordship in the WS, your lordship. Properly,
Is WSA part of the evidence?
your lordship, that was explained, your lordship, properly.
Is explanation also included in the evidence?
Your lordship, I'm leaving it to your
You
lordship.
cannot leave it to us. You have to prove your case.
Yes, your lordship, that is true.
Don't leave anything to anybody else.
Your lordship.
You prove your own case.
Yes, your
You are before the court. You are given the opportunity. You prove your case. Yes, prove it.
lordship. Your lordship will get at page 24, your lordship, if can be your lordship. The same Samed Ali, your lordship, Samed Ali, the grandfather.
The petitioner relies on the voters list of 1966 of village Tuktuki containing the name of Jubair Ali and claims that he is the great grandfather. Thereupon the voters list of 1970 of village Tuktuki, which contains the name of Samed Ali, son of Subaid, and it is claimed that Samed Ali is the grandfather. Thereupon, reliance is placed on the voters in 1985 of village Halapia and Behuguri, which contains the name of Muntaz Ali, son of Samed, and it is claimed that Muntaz Ali is the father. But it is noticed that Samed Ali is of village Tuktuki, whereas Momtaz Ali is of village. Whereas Samed Ali, father of Momtaz Ali, is of village Kholapia and Behuguri. Petitioner seeks to clarify that the family had shifted from village to Kholapia. Relevant material which may establish the shifting may be produced. Next again. Produce whatever material.
Your lordship, I beg pardon if your lordship goes to page.
Next item, please.
Item 15 for bill procedure again.
Whose personal appearance?
Lordship has called the IO and the OC.
You say for tribunal matter or some other matter?
No, they alleged that he died, the husband of the petitioner died because of police torture.
Department has stated respondent fired the petition. Who that respondent seeks some additional SP?
SP.
Yes, 11 years have passed and we wanted to see the case diary.
Yes, ma'am. Case diary.
Where is the case diary?
Malum. In fact, the investigation has been completed and investigation was completed long back. Can you come to page 7 of that report?
Who is Saleha Khatun? Rina Begum, Saleha Khatun, who are they?
Saleha Khatun
Is the wife of the
Wife.
deceased.
Yeah, wife of the deceased.
Solifuddin. Who is Solifuddin?
The
Son of the
Son.
deceased.
And who is Salimuddin? Son. Who is Firuzuddin?
There
He is also another son.
eldest son.
And Rina Begum, daughter. Saleha Khatun,
Saleha
wife.
Wife.
And when were these statements under 161 taken?
But
Around that time.
FR was submitted in 2012. Then they raised objection. A reinvestigation was done at serial number 7, page 7. Lordship will see.
7 of this
This report. The report. Then re-examination has been done. The investigation, ultimately the report of the doctor's report and the PM report, it suggests that he died due to heart attack.
No, whatever, we are not on the reason.
Lordship.
So after this re-examination, FR was again submitted.
Again submitted
On which date?
on 34/23.
13/4,
34/23.
23.
Page, yes,
That is this year.
this year. Page 8.
You file an affidavit along with the final report?
The final report has been submitted before the court, and I'm told that the court has issued notice to the informant.
That's what
Lordship.
you file, bring those materials on record before the court.
The final report, possibly that information.
You don't have a copy with you.
No, final report copy. I have given, this photocopy I have given, handed over. The investigation report I have in the file.
What is this?
No,
This
no,
is to Rahul Daluja, Ratul Daluja.
That is the instruction given to us, a report given to us, and in the case
Where is the final report?
Case diary is there. Final report has been submitted to the court.
We know it is submitted.
Lordship.
We want, where is the copy of that one? You must be having some photocopy or any other form of copy.
No, copy we don't have. It is with the lordship. We'll
See,
obtain a copy.
Even if you submitted the final report to the court, it will go along with the CD. Number one,
Lordship.
you are supposed to be having 4 copies of the CD. One with the SP, one with the circle officer, and one with
The IO.
one with the IO and one to the court.
Lordship.
So you have a copy of the final report. Why don't you file a copy of the final report before this court?
Lordship, fine.
Do it. And once final report is there, what do? We close this petition. We close this petition. Now, whatever you have to do, you do it before the court where the final report had been submitted. Narazi petition, you go and file it there, if you are still agree.
Learned CJM has issued notice.
Understand.
Lordship.
But to pass this order, we want that final report to be formally placed before the court. Pursuant to our order of 7/8/2023, it is stated by Mr. D. Nathland, Senegal advocate, in the presence of the investigating officer, and have also produced a report submitted by the Superintendent of Police Kachar, that a final report had been submitted in respect of Katigora PS case number 291/12 on
34/2023.
on 34/2023. It is stated that upon the final report being submitted, the Court of the Learned Chief Judicial Magistrate Kachar had also issued notice to the informants and others. The final report, a copy of the final report as submitted be placed on record by means of an affidavit. Final report is a public document. You can find it.
No, final report after acceptance only, my lord. My lord, we'll submit it to honorable court, my lord. It has not been accepted or no order has been passed, my lord.
Who had not passed order?
It is placed before the court, my lord.
Mr. Nath, you were answering a writ petition here,
We'll produce it.
where the allegation is no investigation is made. Your statement is we have completed investigation, submitted final report. Why don't you place that on record before this court so that we can close this petition?
Please.
And what will happen with the final report, magistrate will deal with it.
Yes, absolutely. Absolutely. Absolutely.
Why are you hesitant to submit that? And final report is no longer has the status of a CD, which cannot be publicly opened. Once investigation over, even the CD will now be open for everybody's inspection. CD is a confidential as long as the investigation is going on. And final report is also a public document now.
We'll produce.
This one, so for the final, you have it with you. Find one page affidavit, bring it on
Yes,
record.
yes.
Yes. Who is respondent then?
Report to be open. Final report.
Respondent number 10. Sorry.
My lord, before my learned friend said, my lord, today, today we are going to file one petition, my lord, under order 1 rule 10(2) was striking out all the 7
Did not do that.
Yes.
The
Yes.
repetition has already come to an end.
Yes.
Only the formality remains.
Yes, my lord. God bless you.
Personal opinion.
Just mention that.
The report submitted is written back.
madam.
Is there some relevance? Is there some vacuum in the proceeding? इसमें मालूम है अगर किसको केस दर हम वाकई में बताई दो तो दिला the case diary produced by the IO that will retain or it will be
Case diary, you can send it back.
logic.
You retain only the final form,
Logic.
that
Logic.
1 page or 2 page document, you annex it with an evidence with only 1 paragraph. You did not write anything else.
Logic.
Final report has been submitted, copy annexed. That's all.
Logic.
2 sentences. And your confusion regarding the hesitancy of filing final report, that is, CD is to be protected up to the stage of investigation, because if it is made public, the accused may know what investigation is going on. He may hamper or tamper with the investigation.
Correct.
That is the reason why in a bail proceeding, it is a secret document. PP will give it directly to the court and no one can see it.
Correct.
But once investigation is over, it's a public document. Even the accused can examine it if necessary. That's a difference.
Logic.
So once it is investigation over, final report, you can very well place it before the court formally so that we can also pass our formal order.
Logic.
Clear?
Yes, we'll do that.
Yes, Mr. Muti.
Yes, my lord. Last order, my lord, 27/2023, my lord. Director Education Department and Election Commission, my lord.
Lordship, I have received a report from the DO Lordship. After go through the report, I have found some doubt, Lordship,
Sorry,
some doubt, Lordship, because the school
do
is.
you have the register in original?
No, Lordship, it is, I have received the report only, the school is closed from the year 2010. And the certificate is issued on 2013, after closing of the school.
Understand. So the record also must have disappeared
Lordship.
after closure of the school.
Lordship. And on the other hand, Lordship, the school is venture school,
It may be venture also, but only we want
Lordship.
the contemporaneous record we want. So whether admission register depicted this information or not. So what do you do when the school is not there?
My lord, as per admission register, my lord, paid up to 2006, my lord. Fees paid up to 2006, my lord. At that time, school must be there, my lord. Subsequently, maybe, my lord.
Mr. Moti, what is your certificate? See, you are relying on a certificate by the school.
Issued by the headmaster.
Just a minute, issued by the headmaster. What is your certificate? What under law, what do you mean by a certificate?
Certificate means, my lord, some.
Certificate is not a piece of document which establishes everything,
Yes,
whatever is
yes,
written
yes.
there. Now, what is a certificate? Certificate is a document where the person certifying it on the basis of his knowledge
Yes.
or on the basis of public record
Yeah.
of which he is the custodian, states the existence of a given fact. This is the plain and simple meaning of a certificate. Now you say that you are relying on a school certificate issued by the headmaster.
Headmaster.
Certificate was issued according to Madam Kaur in the year 2013
13.
by the headmaster. Madam says, as per record, school did not exist after 2010. So in 2013, there was no headmaster and nobody could have issued a certificate as a headmaster because he is no longer the headmaster. This is number one.
Yes.
Number two, even if we issue a certificate, it has to be based on contemporaneous public record maintained by that person. In 2013, there was no public record because there was no school.
Yes.
Fine.
Yes.
Once the public record is not there, the basis of the certificate goes, so the certificate also is no longer admissible in law.
Yes.
Now you submit.
My lord, in this case, my lord, there must be a school admission register, my lord.
School admission register is not there because the school is not there.
After 2010, my lord, she has admitted in the school, my lord, 2006, my lord.
See,
And she has paid, my lord.
Mr. Putin, you are not understanding or you are deliberately avoiding
No,
and
no,
saying
no,
something
no, madam.
different. It appears you are deliberately saying something
No,
different.
madam. As per,
She may have been admitted in
Yes.
2006. But a certificate issued on the school admission register, which does not exist anymore after 2010,
10.
that certificate has no value in law.
Until
This is what we are trying to tell you. So now
then, my
you
lord, I have to skip this certificate, my lord, and I
have to
one-
skip. Okay, you
my
skip
lord. I
the
have
certificate.
one-
Now you say,
Yes,
say
my
what
lord,
you
one more documents, my lord.
Which document? Yes, Madam Kaur, I think you had done a good work. Thank you. But we'll record your submission. Yes.
And this is one certificate issued by the SDO Civil Business, my lord, and during the refugee camp, my lord. আচ্ছা, ভিতরে
Where is the original of this one? This is a photocopy. Let us take a
Yes,
look at the
well,
original.
Right now, I have no original, but I have to.
Please produce it.
Yes, ma'am.
But this is duration of stay October 1993 to March 2000.
Yes, my
How
lord.
does it help you?
Yes, my subsequently, my lord. Subsequently, my lord, petitioner's father shifted his residence from the camp, my lord. to
He
Dom-
may have shifted,
Yes,
but this document will show that he was in Assam
yes.
from 1993 to 2000. A
Refugee-
man in Assam in 1993 may be a foreigner.
No, my lord. This is the certificate. in
Sorry?
the refugee camp, my lord. During the staying in the refugee camp.
But refugee camp he stayed in 1993, not in 1950.
Yes, my lord. My lord, a communal rights took place in 1993, my lord. He entered
Mr. A.M. Ahmed, again, I know you understand, and you are not a person who doesn't understand anything, because your other submissions doesn't indicate that you don't understand. This one shows his existence in 1993 in a refugee camp for whatever reason, communal violence or
Yes.
whatever it is. But a man who existed in 1993, how do you know that he is a citizen?
My lord, in this case, my lord, petitioner father, during the riot, my lord, petitioner father shifted from Amtenga under Disney PS and staying there, my lord, a refugee camp, my lord.
Okay, we dismiss your petition. If you're not answering, we dismiss it. What else to do?
My understanding, my lord, my understanding.
We understood your understanding, but your understanding is not the answer we are
My lord,
asking.
another documents I have received today.
Some more document.
Yes, my lord.
Produce it
My lord, after some time,
after some time.
Yes.
Okay, after some time.
at 2 p.m.
With 2 p.m., 3 p.m., we
At
don't
2
know, but
p.m. My
after
lord,
some
I am
time.
I'm
Okay, you
submitting
produce it.
another documents.
What you have to show
Yes.
that the father existed prior to 1966.
66, my lord.
So it
A school certificate is here, my lord, petitioner's father.
came back to school certificate.
1968 in his date of birth.
Mr. Motin, if you go on concentric circles, do you expect the court also to follow you all the time?
No.
Then we deliberate only once. And that we have explained you why we are not accepting it. And you had no answer to it. Now, please don't reiterate the same thing once again. If you have some better material, new
Yes,
material, please produce. We'll
At 2
definitely give
p.m.
you.
my lord.
Okay, after some time, you read, you'll be back in 10-15 minutes. Sixteen was it that Mr. Motin's matter, I think. Very key was timing negative.
My lord, I have collect one marriage certificate.
Where do you collect? There's some collection place there or what?
I have got. my lord.
No, in the first time you collected one from one document came,
Yes, my
now
lord.
coming from behind said I collected one more.
And my lord, in this manner, marriage certificate. my lord.
Marriage certificate. No, tell
By the
me, who is the father of,
Habibur Rahman,
where does his name appear?
my lord. Yes, yes. ma'am. His name appear, my lord, first time in the voter list of
His number
PS 25.
25. Habibur Rahman, 25. 1989.
89, my lord.
So it's only 89.
Yes. And my lord,
His father is father of
is-
Habibur is Haran Ali.
Haran Ali,
Where does the name of Haran Ali appear?
page 19, my lord.
Page 19.
19.
19. But he is of Helengor Chor,
Yes, my lord.
and this one is of Amtaka.
Amtenga, my lord. They,
Okay, Amtenga.
that's why, my lord.
Amtoka Tenga.
Yes, that's why, my lord, directed Mr. Ali to produce the down. Yes.
Amteka Tenga.
I have received the voter list of Bengal's relationship. And as per my.
The Mr. A. Ali, non-competent election Bureau, states that the complete upward and voters list of village, Helengasore and Amtaka are yet to be obtained. It states that the upward and downward list of village Helengasore had been obtained, but the list of Amtaka is yet to be received, list on so and so. The petitioner relies upon a school certificate, we are rejecting it. And accordingly, by the order of 27/2023, we required the Education Department to produce the admission register in original of the Nolonga High School. Full stop. MSS called and Council for the Education Department stated that the authorities in the Education Department from the record had verified that the Nolonga High School ceased to exist in the year 2010,
Yeah.
whereas the certificate was issued to the petitioner in the year 2013. Accordingly, it has to be understood. And the certificate is noted to have been issued by the headmaster of the school. If the school did not exist after 2010, it cannot be a situation where the headmaster existed, where the headmaster of the school existed in the year 2013. Secondly, it has also been told that upon closure of the school, the admission register in origin is no longer available. If the admission register is not available, it cannot be accepted that the headmaster can issue a certificate in the year 2013 on the basis of a non-existent admission register. from such point of view, were unable to accept the school certificate for reliance of the petitioner. But however, Mr. M. Ahmed, counter petitioner relies on the voter of 1989 containing the name of Haran Ali, son of Tarifullah at 816 and that of Habibur Rahman, son of Haran at 822. And it is claimed that Habibur Rahman is the father and Haran Ali is the grandfather of the petitioner, and the name of Haran Ali appears in the voters list of 1966 of village Helengasor. In the circumstance, there is a requirement to examine the upward and downward voters list of the two villages indicated above. List on so and so. Mr. M. Ahmed, are you relying on this one? Refugee?
My lord,
Say yes or no.
I skip this certificate.
No,
also, my lord.
you are relying or you are not relying?
No, my lord.
Not relying.
Back me return. Kind.
You want it back also?
Yes. If I am not relying.
Let's stop. Bad video. A report submitted by MS Score is returned back. We have recorded your. What is this?
In this case, Rashmi directly produced the upward and downward total list of villages from Sakimari grazing reserve and village 182 Mudusori. So I produced the upward and downward of the Sakimari grazing reserve.
Other one is not available.
Other one is
Other one is also there.
in this year, the petitioner's grandfather's name Hassan Ali, son of Rafatullah, and Rohiman Nessa, wife of Hassan Ali, their name is there.
In which 66
1970.
serial number?
The 1960 serial number is 1214.
1214. 19 second page.
1960.
1214 Hassan. Who is Hassan Ali?
Grandfather.
Grandfather. And Rohima Nessa? Grandmother. Roshan Ali?
Absolutely, appears that he is also the son of
Son of Hassan Ali. And now who is the father?
Mohar Ali.
Page number?
It is not his name is not in 1970.
Okay. Now
In 1970 also, the name of the grandfather, his name is there.
serial number?
Serial number is 11116.
111 111 Hassan Ali. Hassan Ali is the grandfather. Rafatullah. Grandfather. Rohiman grandmother. Now where does the name of
Thereafter, the name is not appearing in Sakimari grazing reserve.
these two names? And it started appearing in
As per our record, I have submitted the 1997 voter list. There only the name of Mohar Ali, not along with his father.
now what happened to Hassan Ali? Because Hassan Ali in 70 is 59 years and Rohiman Nessa is
His name
49 years.
subsequent to there, his name is not appearing in Sakimari grazing reserve. And then let's say in the petitioner in page.
No, that may not appear because Hassan may have died. Then does it mean that Mohor is the son of that Hassan?
No, that's why petitioner has annexed on voter list of page number of 1985 of village 142 Budusori.
Modhusor.
Budusori.
Budusar. This is again the third village.
Second.
What's a second village? Okay.
total is the petitioner the next lordship. In 1985, the total is that I have received from the department. As because 1985, the sequence is not matching and the name is also not appearing in lordship.
The record of the election commission and the one produced, they are not matching with each other.
Only the one thing is different. In the top of the total is that they have submitted on comic number is 87 and in there it is 86. So I will time to want to verify your lordship.
Mr. A. Ali, Land Council of Election Department has produced a voters list of 1966 and 1970 of village Takimari Grazing Reserve, which contains the name of Hassan Ali, son of Rafatullah at serial 1214, and that of Rahiman wife of Hassan Ali at serial 125. It is claimed that Hassan Ali is the grandfather and Rahiman is the grandmother. Name of Hassan Ali and Rahiman also appears in the voters list of 1970 of village Takimari Grazing Reserve at serial 1116 and 1117 respectively. But the later voters list of Takimari Grazing Reserve do not contain the name of Hassan Ali and Rahiman Nessa. The voters list of 1997 of village 142 Budusor contains the name of Mohar Ali, son of Hassan Ali at serial 04, and that of Sarijan Nessa, wife of Sohar Ali at serial 05. But the petitioner also relies upon the voters list of 1985 of village Budusor, which is annexed as
Section number 4.
sorry, annexed a 4 page 23. But the voters list of 1985 obtained by the election, produced by the election commission, but it has been produced. But Mr. A. Ali, election commission states upon examination of the two records, states that the serial number of the voters in the list at annexure 4 to the writ petition and the list provided by the election commission do not match with each other. In the circumstance, Mr. Ali seeks for an adjournment to examine the difference. List produced by Mr. Ali returned back to be produced again on the next returnable day. To do the needful as required by the order of 22/2023. Petitioner adjournment produced relevant to show that petitioner Johura is the daughter of Kantumia.
Yes. My lord, I have already filed additional affidavit.
Which page?
My lord, page 71
71.
of my additional affidavit.
Page 71. What is page 71?
Relevant part is, my lord, operative part is, my lord, page 74.
First you tell us what it is, then you go to the operation. It is Damavati of village Borbita.
Yes.
So where does the name of Sabir Ali appear? No, Kantumia appear.
Kantumia, my lord, kindly have a look in page page 73, my lord.
Kantumia at page 73.
Yes,
Not in the Jamabandi. In which voters list the name of Kantu appears.
yes. In 65, my lord. Page 34.
65 9 years old. 65 9 years old. Page 65. There is
My
no
lord,
page
my lord,
65.
34.
Page 34.
Yes, my lord.
You said some 65.
1965 voter
Oh,
list.
voters list 65. Page 34. 65 Borbita, Kantumia. Okay. So now Johura Khatun,
Yes.
Kantumia. English language is written from left to right or from top to bottom?
My lord, it is. It's
Hmm. How do you write? Urdu is written from right to left. English, I think, is written from left to right. But if you come to page 71, it is from top to bottom.
my lord, it is not, it is the
How-
official document, my
How
lord.
do you expect us to read all these things?
আমার জহুরে খাতুন জহুরে আছে হাজিরে আছে ভাই বোনের নামদারি বলতে
Where is the order of the circle officer?
well this is they have produced. It's fine.
In the Jamabandi, the circle
My lord,
officer
the order of
always
circle
referred.
officer, my lord,
Where is it?
kindly have a look, page 74.
74.
Four.
Order dated.
My lord, 27 2023.
When did Kantumia die?
My lord, he died around 2012.
Why the mutation is now made in 23?
My lord, it was not done, it is their family, joint family, my lord.
No, why family had done it after 12 years?
Well, earlier they have done their mutation.
Where?
My lord,
No. Why do you do the mutation to rely in a court proceeding
my lord,
in a foreigner's case
my lord,
when you are required to prove whose daughter you are?
my lord, in the
Why
last
this
one,
mutation could not have been done when the man had died?
my lord, it is the petitioner city, they feel it is not required because they have joint property.
Mr. Talukdar, please be serious in your answers.
Yes.
This is not a drama stage you are acting upon.
Yes.
You are in a court of law. Please
Yes.
keep that in mind. We are asking a relevant question.
Mm.
When the issue is who is the daughter and who is the father,
Yes.
to establish, you rely on a Jamabandi mutation order. We are asking you why it is required to be done at a stage when you have to produce that material before the court and not at a stage when the man had actually died.
Right.
And you are just trying to show some movements of your hand and say that they'll do whenever they feel like.
My
So if you say whenever they feel like, we also understood that they had felt like Because they have no other material to prove, so they have manipulated this one. Very well. We dismiss your petition.
This honorable court has directed by virtue of the order dated 22.
To do the mutation. We have directed you to do a mutation.
No, not.
Don't tell me that.
To produce a document which related that comes.
So therefore, this is a document which is created after we required you to produce a document.
My lord,
When we ask you to produce a document, we ask you a pre-existing document, not a document to be created and brought to the court. Here it is. Make an inquiry, find out under what circumstances mutation. And that too, although it is of village that Borbita, nowhere the father of Kantumia is written. Everywhere it is written, so-and-so had replaced Kantumia, but who is Kantumia, that is not there anywhere. Oh, no, one it is there, number 2.
number 2 is there.
Kantu Ali Mia
Yeah.
Pita Sobed. It is there. The original records of the mutation case number BAJSALR stroke 2023-24 stroke 2024 000-558 stroke FMUT of the circle officer be produced before the court for an examination as to under what circumstance the order of mutation dated 27/2023 was passed. Circle officer Horupeta. Copy of the order be made available to Mr. P. Sharma. Fashion is mutation করা ট্রেন্ড আছে সব মিউটেশন আপনার 2018-19 করা হবে Mr. Pai, have you noticed one trend? Have you noticed one trend? Initially, it was all panchayats and Gambura. When questions were put forth on the applicability of law, that has lost its no longer in fashion. Then came the school certificates. When school certificates are examined from the basis of the original record, slowly it is going away. Now the latest fashion is mutation order. And invariably all mutation orders are from 2018-19 and later.
My prayer is that the record of all the
Sorry.
mutations.
So not only your prayer, your further requirement, go and examine everything. Find out. If you tell us, give some more information, it is helpful for us as well as helpful for you also. Why don't you make some inquiry? Who is this mutation? Where they have done? It is also possible that these mutations are only in paper. Kantu Sheikh must have died long back. His son and daughter must have been having his land. They are somebody totally different. And mind you, it appears to us, especially that Sel did in the morning, no one is actually claiming any land on the basis of these ones. Actual transaction of land from one person to another, change of title possibly doesn't take place anywhere. It is only the relevance of the document which shows that so-and-so is the son of so-and-so.
Actual position is not there.
So why do you have to start making inquiry through your mandal and all? Who is actually, where is the land and who is actually occupying the land? Last time it came, the land also appears to be non-existent because the Dag number, Pata number is not matching with any such owner.
Records.
Check up, do some little more work.
Yes.
Activate your system, your authorities. Yes.
May I please, my lord? Lordship, the petitioner number 1 and 2, my lord, both are husband and wife, my lord. But above that, my lord, petitioner 1 and 2 also cousin brother and sister, my lord.
Sorry,
Cousin brother sister.
who?
1 and 2, my lord, husband and wife, but the father of the petitioner number 2.
They are husband and wife as well as cousins.
Cousins.
Okay, very well.
The petitioner number 1's father died in the year 1964, my lord. And my lord, might have, my lord, his name not appeared in the any voter list, my lord. But there is a one sale deed, my lord, in the year back 1961, my lord. Where my lord, petitioner father purchased a land.
Where is that sale deed?
My lord, page 21, my lord. But original is with record, my lord.
Yeah.
Yes, my lord.
Page 21. So here, whose name appears?
Petitioner father's name, my lord.
What is the name?
Uh,
Montop.
Muhammad Surzat Ali.
What Ali?
Surzat Ali.
Suraj Ali.
Surzat.
Surjat Ali. Huh?
Yes, my lord.
He is the purchaser.
Yes, my lord.
Pita Seku.
Yes, my lord. Seku Sheikh.
Seku Sheikh.
Yes, my lord.
Hang.
Manipur 2. Manipur 2.
Manipur 2. Manipur or Anipur? Manipur.
Manipur 2.
Manipur 2. Okay.
My lord,
So,
after-
Kurjat Ali of Manipur 2, he is the father.
yes, my lord.
And who is the petitioner?
Petitioner
Jalimuddin.
Jalimuddin and
Which material shows Jalimuddin, son of
yes, my lord. After the expiry of his father, my lord, petitioner went to her maternal home, my lord. And he resides there, my lord, and married there, my lord.
and who is the wife of Heri?
Wife is
Kurjat Ali.
Hajara Khatun, my lord.
Hazera Khatun is the wife of and mother of the petitioner.
No, my lord, sorry, my lord. Wife of petitioner number 2, my lord, Hajara Khatun is. Hajara Khatun is petitioner number 2.
Why two petitioners?
And there are more than 2, my lord. Six
Why?
petitioners.
Why so many petitioners?
But the judgment was passed against all these petitioners.
Against all of them.
Yes.
Where is the judgment?
Lecture may come page 94, my lord.
How many cases? One reference.
Yes, my lord. And my lord, relevant portion is page 97, last para, my lord.
Jalimuddin. Jalimuddin is the petitioner.
Yes, my lord. Hajara Khatun also the petitioner, my lord.
Hazera Khatun is the wife of Jalimuddin.
Yes, my lord.
But you said Hazera Khatun is the wife of
No, my lord.
Khuzrat.
No, my lord. I'm sorry, my lord. That
What is, who is the wife of Khuzrat?
yes, my lord. The wife of Khuzrat is Hajara Banu, my lord.
What is Hazera Khatun? What is Hazera Banu?
My lord.
Now, this time they are different persons. And if the necessity arises, they become the same person also. Yeah, sometimes you write Banu, sometimes you write Khatun. That's a common submissions. It's being made. Why references against 7 persons in one reference? And even if it is one reference, let the tribunal register 7 different cases and find out individually. Hmm. Suppose what will happen if Jalimuddin, we conclude that he is a citizen. But if Hyder Ali is not his son, then what will happen?
Yes.
Hyder Ali will also be declared to be a citizen along with Jalimuddin. So will there not be a presumption that Hyder Ali is the son of Jalimuddin? But if you refer Hyder Ali separately, Hyder will also have to prove that he is the son of Jalimuddin. Right?
My lord, as per reference, my lord, reference.
Now, just because police, when making the reference, thought that Hyder is the son of Jalimuddin, so he becomes the son of Jalimuddin. He may not be the son of Jalimuddin. And by virtue of this presumption, if Jalimuddin is declared citizen, Hyder
Becomes it.
automatically becomes a citizen without proving his own case. What do you do? Send that.
Yes.
Now, although a reference is common, you register 7 separate cases and determine separately. And there you prove once again whatever material you have.
My lord.
Third,
AM.
E.M. Hassan and also Mr. G. Sharma.
Lordship. The reference was only against number 1.
No, but tribunal says has been received from against 1, 2, 3, 4, 5, 6, 7.
But my lord, as per my, I have the copy of the reference. my
I
lord.
know, but the others' names must have
My
been written. there.
name,
That's why.
in the investigation report, name was mentioned.
It is noticed that case number FTC to 242 stroke 2016 bracket new number corresponding to FTC 1533 stroke 12 bracket old number before the Foreigners Tribunal number 5 Morigao was proceeded against 7 persons, namely, page 94 of the same. Because identity is shown in the reference order to be the sum of could verify what is either sum or either যদি অন্য মাঝে সময় বেশি এখানে করতে let's separate the place কি বলবো again so and so. We have also perused the inquiry verification report of the police authorities, which apparently was against Muhammad Jalimuddin, son of late Suraj Ali of village Goyal, Goial, of village Goyal, police station Bhuluka, police station Bhuluka in the Morigao district. In the of village Solmari, village Solmari police station Moirabari in the Morigao district. Other one was the Bangladesh. Notice that it was a and the verification was only in respect of Muhammad Jalaluddin, where MUSTT Hazera Khatun is shown to be his spouse and what? and Muhammad Hyder Ali, Muhammad Wakin Ali, Muhammad Zahirul, Muhammad Imadul, and Muhammad Ansarul to be the son.
My lord, it's Anarul.
The Anarul, no, here it is Anarul to be the sons of Muhammad Jalimuddin. In the circumstance, reference case was registered against all the 7, namely, as indicated above. The verification report containing that Muhammad Hazera Khatun is the wife, Muhammad Hyder Ali, Muhammad Wakin Ali, Muhammad Zahirul, Muhammad Imadul, and Muhammad Anarul are the sons, are only as recording in the verification report without any further assertion that in fact the aforesaid persons are the sons of Jalimuddin. If the recording in the verification would be incorrect as regards that Hyder Ali is the son of Jalimuddin, comma, any declaration in respect of Jalimuddin, if declared to be foreigner, would adversely affect Hyder Ali, and if declared to be an English citizen, would give him an undue benefit without actual determination. In the circumstance, we review that it would be more advisable and prudent to register separate reference cases against all the aforesaid 7 persons and give an opportunity to them to discharge the burden to prove that they are citizens individually and thereafter pass separate orders in the 7 separate references that may be registered. Accordingly, matter remanded back to the tribunal to register 7 separate reference cases based on the verification and the reference made by the police, and upon issuing notice to proceed against them as per law. The petitioners, the proceedings would be at liberty to rely upon any material that they may be advised to rely, that they may desire to rely upon to substantiate, to discharge the burden to prove that they are not foreigners. All the 7 petitioners to appear before the tribunal on so and so, and upon their appearance, the tribunal shall register 7 separate cases and proceed against the persons as per law.
31st August.
In the event the petitioners do not appear before the tribunal on the aforesaid date, the respondent authorities may proceed against them as per law.
Right.
Yes.
Yes, item 20.
Item 20.
What item 20 of Lordship was asked to produce.
Yes, I was asked to produce the instruction letter for public utility.
Adjourned the prayer, Mr. A. Ali, then the Election Department for production of the concerned voting.
21.
Lordship, further than
For the requirement of the order 26/7/2023, MSP Ghosh and petitioner 6 for some further time. Pray allow.
22.
Yes, full record. You have it. You have it with you. What does it say?
Lordship, this record are manipulated.
Huh?
These records are manipulated.
Manipulated.
From the year 1985 to 1996, all entries are made by the same ink. And after completion of 1 year, there was one gap, but in that particular Here, the gap was not blank. It was entry by the name of the petitioner.
Some different thing, different. Till now, how many school records were accepted? Two.
Only two,
Two till now.
Lordship.
Hmm. Kuntu. Serial number.
Serial number is not there, Lordship.
Hmm.
Serial number is not there.
Starting of 94 months. Year 94. First one.
Line, 11 number line.
Aziron,
Aziron.
we got it.
Yes, madam. Prior to that, madam, 92, there is a gap.
Sorry.
Lordship,
After 92, 93, there is a gap, madam.
Ah.
93, 94, the gap is filled up by
Okay, you
10.
want to say year wise, they're keeping a
Year-wise
gap.
was one
Previous
gap.
also, your lordship.
Means in all the years, the gap is there.
Earlier, it is
Earlier pages, there was one gap between 2 years, but in that particular years, no gap is maintained.
Okay, between 90 and 91, one gap is there.
yes,
Between
92, 93, there is a gap.
91 and 92 possibly gap not required because they are.
A different piece.
Who is this Kosor Ali?
That is also new entry probably. That is also,
Give
that is also new entry.
the name record. Whenever Kosor Ali comes to the court, you put out this.
That is also new entry, but we have seen.
And it will lines and particular piece of drawing an extra line he has been put in. And different handwriting again. Or serial number
No serial numbers.
serial number system stopped. Creating problem.
And in fact, I don't know whether in 1985, the ball pen was existing on it.
Which paper?
1985 ball pen, yes, this is 85.
85 it was there.
Yes.
85 I remember clearly it was there.
And it is seems melody from 85.
No, because when we were at school, ball pen started appearing for the first time.
And when it is
It was in the 70s.
and from 85 melody, it seems to be same single
Same
paper, single melody ball pen, single ink.
From 85.
Yes, to 90 up to
96.
96. Right. Prior to that, it was okay. Prior to 85, it was well maintained manner.
Prior to 85 it was.
Well maintained.
No, this is also continuous paper. Only thing the pin has come out.
Yes,
Because it got rusted and the rust must have eaten up the paper, so it has come out. Otherwise, it is complete. It's not single sheet. It is.
no, it is not single sheet melody. It's a continuous piece.
So raise.
Yes,
Both sides are there, but only thing you see the pin mark
yes.
because of the rust, it has come out.
Yes, that is true.
Hmm.
No matter the
But the gap is irrelevant.
Yes.
What you were saying. And able to gap in IR. From 1995 onwards,
there is no
there is no date also.
no gap. And
Free
there
for
is
all. Signatory A Ali. It is so. It is what? Yeah, it is a money. Signature to go in, want to study. Able for the day how you say. পিছৰ ফালে সি যি পাই তাকে মাৰা হ'ল। Date of birth will be it. I don't know. No, porque, no, what's going on there? I will find admission reason on Bitty Pudi. This is not admission register. This is not admission register. What does it mean? Bitti bohi. Bitti means your stipend. Scholarship. Sorry. 40 bohi.
40 has been written as 40.
अच्छा 40 bohi. अच्छा 40 is admission. Okay, you examine sometime. We'll take up next week. See what is to be done with this.
40 minus. I have.
And from 1996, there is no date at all. Admission.
No, nothing is valid.
So everybody is free to come in.
Yes. And from 85, my lord, it seems to be using the same pin, my lord.
From 85.
Yes, 85 to my lord.
Because every year the
Every year using the same pin. Same pin. 96.
more. Man does not use different pens for different purposes. See, if I give my own personal example, I have different pens for different purposes because it's very difficult to find a pen whenever you want to write something. So you keep one pen there only. So if that is so, if one purpose I sparingly use, then one pen may continue for 7-8 years also. It will never end. But if the pen I use for signature of my orders, that finishes every month because every day you have to put so many signatures. That you will find a variance because. But another pen used for some other purpose that may be continuing for years also. You don't expect to carry one pen all the time. Then whenever you have to write, you will write only with that pen. But handwriting may show something. Because when something is written separately, the handwriting is always different. But when you write 15 entries in one go, slowly the handwriting becomes a little more monotonous. Okay, we'll list on so the admission registered origin had been produced by MSB Jagalanga adjourned to enable the Land Council for the Home Department to examine the savings. List on so. See what kind of order we can pass. Think about it. Because if our order is wrong, also it won't look very good.
Direct for making an inquiry by.
Sorry.
Direct for making an inquiry on.
No, first you examine, certify yourself. We'll definitely order an inquiry. Because this appears to be a case of manipulation. That's good. We have filed some affidavit. Sharda Kumari, daughter of Bideshi Shah, named 71 Vishnupur, Raipur. So Sharda Kumari's name appeared in 71 in that place in Bihar. And now Sharda Devi Gupta, wife of Vijay, is of Dhupri. That they are the same person. How do you establish? Have you annexed the evidence of the sister-in-law? Which one? 54. So, page. Devarati Devi, page 60. So, is Devarati Devi ready to come to the tribunal to depose? What? Otherwise, how will you prove? Some family member of the Bihar family, you cross-examine and verify whether they are actually from the Bihar family. Heard? No, we'll allow Devarati and you also any further if you want. Heard MSD Ghosh, Land Counsel for the petitioner, also heard Mr. Sharma. The petitioner Sarada Devi Gupta, alias Sarada Devi, had been referred to the Foreigners Tribunal number. What is it? Had been referred to the Foreigners Tribunal. Foreigners Tribunal number 1 at Dhubri for rendering an opinion as to whether she is a foreigner under the Foreigners Act 1946, resulting in registration of FT number 2190/D/10. The tribunal rendered an opinion dated 27/8/2019, declaring the petitioner to be a foreigner, being aggrieved. This writ petition is instituted. In the writ proceeding, the petitioner refers to a voters list of 1971 of village Bishnupur, PS number 99, / village Raipur, এইটো আগৰ অৰ্ডাৰটোতে আছে 12/5/2003 অৰ্ডাৰতে আছে Raipur Bindagawa PS number 446 the said voters list is of the given place in the state of Bihar the name of Accordingly, the petitioner claims that she is Sharada Kumari, daughter of Bideshi Shah, whose name appears in the said voters list of 1971. Accordingly, it is sought to be established that firstly, the petitioner existed in the state of Bihar in the year 1971, thereafter came to Assam upon being married to Vijay Kumar Gupta and is residing in the state in the Dhubri district in Assam. Petitioner also accordingly seeks to establish that she is not a person who came to the state of Assam from the specified territory, but she is a person who is originally from the state of Bihar. To establish that the writ petitioner Proceedee Sarada Devi Gupta is herself the Sharada Kumari, daughter of Bideshi Shah of the 1971 voters list, the petitioner seeks to rely upon the evidence to be rendered by Devarati Devi, wife of late Shama Shaha, who is aged about 82 years and is a resident of village Bishunpur Tola Bandhu Chapara. It would pay 60 to say. Under Borhara police station in the Bhojpur district of Bihar. Devarati Devi, in her evidence on affidavit submitted before this court, states that the petitioner Sharada Devi Gupta is her sister-in-law and she has the special means of knowledge as required under section 50 of the Evidence Act to establish that Sarada Kumari of the daughter of Vishnu Shah of the 1971 voters list is itself Sarada Devi Gupta, the writ petitioner proceeding. Petitioner also seeks to rely upon evidence to be rendered by, who is the other person? By Subhas Gupta, son of late Bharatlal Gupta of Dhubri district, who also claims to have the special means of knowledge that Sharada Devi Gupta, the petitioner proceedee, is herself the Sharada Kumari, daughter of Vishnu Bideshi Shah of the 1971 voters list of a place in the state of Bihar. Considering the matter in its entirety, we remand the matter back to the tribunal to enable the petitioner to examine Devarati Devi as well as Subhas Gupta, who claims to have the special means of knowledge as required under section 50 of the Evidence Act to establish that the writ petitioner Sharada Devi Gupta is Sharada Kumari, daughter of Bideshi Shah of the 1971 voters list of the given place in the state of Bihar. The respondents in the Home Department may make their own verification and submit report before the tribunal. Upon doing the needful, a reason order will be passed. The respondents also may cross-examine the two witnesses as may be advised. Taragote, reason order. Thank you.
24.
Yes, 24. Revenue Department to produce the origin of the Jamabandi. Acha, has produced, right? Has produced. circumstance of the mutation. Are you satisfied or you want to question? Huh. Huh.
Soholot Sakina Khatun.
Okay, we'll hear you.
Only one thing I want to indicate, my lord, your lordship may kindly see the yes, Jamabundi copies there, your lordship. The last part of
No, we'll hear you. If you have to say something on list on that data. Tomorrow, today there will be less time to hear this kind of
Yes.
thing. So next week, next.
Item 25.
Means that mutation is not reliable according.
mutation, my lord, the husband name is something different.
Okay, maybe of somebody else.
Yes. But
Or you do one thing, you make an inquiry and submit a report.
yes, madam.
The respondents in the Home Department may make an inquiry and submit a report before the court as to whether the writ petitioner proceeding and the name of the person in whose name the mutation had taken place are one and the same person.
Yes. Initially, the mutation, father husband's name is written as Sami Kalu Mandal. Then it is corrected in the father's name, my lord.
Understand?
But
No,
the-
they just go to the office of the mutation and find out. And best form of verification is go to the house of that person. Because that family is unlikely to say a wrong statement to protect some stranger. If they say this person is not of our family, end of the matter. Your purpose is served.
But my lord, as your lordship's earlier of this seat, my lord.
In
can
one
be
case,
some-
it happened, in fact.
Yes.
The report came that that family says, no, we don't know this person who is.
Yes.
it. So that is a very good material to the court to reject everything. Yes,
I am Ortona Shah.
a copy to order to Mr. Jishan.
Sri Kumar Shah, and mother is Porunbala Shah.
Page number
Page number 35, 36.
36. Sushil Saha.
Sushil Shah.
Who is he?
My father.
Sushil Saha is the father of which village? Gaon Bipuria.
Bipuria.
Okay. Now, which material show that Sushil Saha is the father?
As per mother evidence, Porunbala Shah.
Where is it?
PW2,
Page number 44.
44.
Bipuria. What do you do? Go back. Sushil Saha's 1970. Wife of Sushil Saha is Orunbala. She is also a resident of Bipuria. She says that Orchana is her daughter.
They may produce the voter list of 1970, dear my lord, because 70 voter list doesn't contain the name of my lord.
It does not. Produce the complete voters list and also some voters list which may just a minute, which may contain Sushil Saha and Orunabala in the same voters list.
Can also rely upon the evidence of PW3 election officer.
The petitioner Orchana Saha was referred to the foreigners tribunal number. Referred to the foreigners tribunal number 1 Nalbari for rendering an opinion as to whether she is a foreigner under the Foreigners Act 1946, resulting in registration of FT bracket null case number N57/17 2018. Tribunal rendered an opinion dated 21/1/2020 declaring the petitioner to be a foreigner, being aggrieved. This petition is continued, is instituted. In the writ proceeding, reliance is placed on a voters list of 1970 of village Bipuria town, ward number 4, police station Bipuria in the Lakhimpur district, which contains the name of Sushil Saha, son of Sitanath, at serial 398. It is claimed that Sushil Saha is the father of the petitioner. To substantiate the same, petitioner relies upon the evidence rendered by OPW2 Arun Bala Saha, wife of Sushil Kumar Saha of Bihpuria, who had deposed that Archana is her daughter. Accordingly, the petitioner claims that the burden under Section 9 had been discharged. Burden in Section 9, Foreigners Act 46 had been discharged. A question would remain as to whether the OPW2 Arun Bala Saha is the wife of Sushil Saha. To establish the same, the petitioner may produce any relevant voters list of village Bipuria, which may contain the name of Sushil Saha and Arun Bala Saha in the same voters list. The complete voters list of 1970 as well as all subsequent voters list of Bipuria be also produced before the tribunal. Upon doing the needful, the tribunal to pass a reasoned order, the respondents in the Home Department may make a verified submit report as well as cross-examine Arun Bala Saha if so advised.
Always submitted an election officer cross-examined. Examine, cross-examine.
The evidence of the election commissioner is found to be irrelevant for the purpose of this writ petition.
In
Next item.
1997, my lord, I am with my father, casted vote.
Item 26.
You produced all subsequent voters list, do everything. 97 with the assay from there. Yes, yeah.
Report on 26 and 27.
Providing report.
26.
I also filed one additional affidavit.
You have submitted a report.
No, my lord.
Adjourn of the prayer, Mr. J. Pine, for the report as indicated in the order of 1/8/2023. There's a judicial order. We have to recall that order otherwise.
That report, but I filed.
Yes, we'll take note of your affidavit.
Item 27.
27.
Report is not yet coming, lord.
Sorry.
Report is not yet coming, lord.
Ah.
Here also.
On the prayer, Mr. G. Sharma, Home Department, adjourn for the report as required by the order of 21/7/2023. Based on so and so.
Item 28.
28.
This case, OVS and evidence was filed also. Thereafter, the petitioner could not appear.
You negotiate the cost with Mr. Pine, whatever cost you said imposed, petition allowed. Next item.
Item 29.
Mr. Pine, tell him the cost.
Brother, the expert image.
Sorry, pass.
28.
5,000.
M.I. Hussain.
Key number 22. Key number 1 is
Yes.
Item 29, my lord.
Yeah, goes to expert order to Mari Diva, subject to what? Yes, Mr. Pine, for the Home Department to obtain verification from the SP on the authenticity of the Jamabandi.
Sirajul.
Adjourn on the prayer, Mr. J. Pine of Home Department for doing the needful as provided in the order 27/2023. Report is not there.
Report is not there.
Item 30.
30, my lord, I have been asked to file a affidavit in this case, my lord. The affidavit is not yet
The
complete.
same order, J. Pine. Did you?
What is? Item 32 for orders.
2, 4. What is this Nagaland matter? Custodial debt. What is the stage of the proceeding? Has the pleadings been exchanged?
Yes, already.
Affidavits filed? Counter affidavit filed? Do you want to file counter affidavit? You don't want.
Otherwise, in the last occasion, they have taken time to.
Last occasion, Lazima court, none appears for the petitioner.
I have taken steps.
10-5 P. Bhonto stated in the
Took steps
respondent
of
to may be
respondent
holding
number
some
12.
other post.
Yes.
The Advocate General Nagaland may inform the court
He-
about the same.
He is now, my lord, posted at.
No, has he been served?
Yes, Lord, yes, Lord.
Yes, yes. He contacted me.
No,
He
just
is
a
now
minute.
in the traffic control room in Mutation. He may file his. Affidavit. He may file.
Gotcha, service complete.
Lord,
When do you want?
he. 2
Hearing,
weeks time, then he may file his affidavit, my lord.
sorry.
He may file his affidavit if
Who?
required. Respondent number 12, my lord.
The order of the Lazima Court of 36/2023 shows that notice about respondent number 12 had been served. Adjourned for 2 weeks to enable respondent number 12 to file any affidavit if so
Lodge.
advised. List on so and so. If no affidavit is forthcoming or
1 week time may begin so that he can file his.
one
affidavit.
time.
He
further-
contacted me.
Okay,
actually.
one
He
week.
said,
DD.
Lord.
List on so and so. Next day we'll hear it.
Yes, my. Oblige.
Item 33.
How was he killed, this man?
No, it's a suicide matter, actually, my lord.
Inside
is
police,
suicide, my
inside police station. Yeah.
Custodian. He is not actually.
No, no,
he is
in the
not-
jail or in the police station?
No, jail, my lord.
Jail. How did he
Custody.
die?
He hanged himself. He.
Death by
lordship
hanging,
is-
death by
Yes,
hanging.
my lord.
Where is the postmortem report? So postmortem report in which page? Page. Go take it. Page. Third. No, আগৰ matter page. Itu কোনটো দিছে? Page 30. Page number 27. কেনেকে মৰিলে চাওচোন। চাব লগা আছে আজিয়ে কৈ থৈ দিওঁ নহলে আকৌ এদিন 27 31 31 Death is due to asphyxia following hanging. And what are the injuries in the neck? External appearance.
External appearance.
Abrasion on the left
Left.
cheek measuring so and so. On the something bruise on both on the back of right thigh. Bruise so and so ligature mark. Oh.
As per
No,
the,
no, what is, no, we're not on your reports and all. What is understood to be hanging?
a suicide case, my lord, that he.
Suicide is the effect of,
Lordship.
what do we understand by hanging? What is the basic ingredient requirement of a hanging?
The
Just imagine something is hanging.
lordship.
What is the basic requirement?
The thing that he used for hanging,
No, not forget about thing. Suppose he is hanging in the air also
lordship.
without anything. What is the requirement of a hanging? When something is hanging, it will not be touching the floor.
Lordship,
Agreed?
lordship.
Otherwise, it cannot be hanging. It will be standing.
Right.
Look at page 24, 22, 33. The feet appears to be touching the ground. How can it be a case of hanging? দুখন বন্ধ আপাতত ব্রুট রাইট সাইড লেফট সাইড it's a death by hanging or it's a hanging after death.
The report says.
I know your report has to be as
Lordship.
per yours. It's a looking at page 32 picture.
Lordship.
It's a death by hanging or it's a hanging after death. How does it transfer to you?
The feet, my lord, seems to be, my lord, yes,
Uh,
touching the ground, my lord.
So
That's
moment, that's why I said, what is the
Lordship.
imperative of hanging? Hanging
Lordship.
means it
hanging.
will not be touching the
Lordship,
ground
Lordship,
by whatever means you are hanging.
Lordship.
So moment the feet is touching the ground, it is not hanging. This is number one. Number two, you notice the face of the person.
My lord,
The mouth is closed. In a case of hanging, invariably the mouth is open and the tongue comes out. Read the Modi's book.
my lord,
So therefore, we are asking, plus there are numerous injuries on the body of the person. Possibly with that much of injury, he did not have the strength left in him
the
to
report,
go and commit suicide. Because to commit suicide also you need some strength on your
Lordship,
body.
Lordship, Lordship. The injuries were also there before he was
That's right.
arrested because. he
So
had
a
some-
person injured to that extent, does
lord.
he still retain the energy to go and hang himself? And therefore we are asking you, looking at a photograph,
Lordship,
it appears to be a death by hanging or it's a hanging after death. You answer on the next.
my lord. My lord,
And try to justify yourself
Lordship.
with that Modi's legal jurisprudence,
Lordship.
medical
Let-
jurisprudence.
we'll work on
See,
that.
what are the effects and signs of a hanging, whether those are present in the present
lord.
case.
Item 33.
Obliged.
Twenty-fourth.
Yes, madam, Mr. Pine objects to the condonation of delay of 1008 days. 6 way to make his submission on the concept of delay in a writ proceeding. What do you do?
Well, simply I'm showing one provision because in foreigners rules 1964, my lord, there is a provision for review. And that
No,
provision,
this is a delay in a review petition.
yes, madam. Review petition.
Petition dismissed, then review petition was.
308 days means converted to years.
4 years, probably.
Almost
2017,
It's 3 years.
17.
He was in the detention camp.
Does the detention camp prevents a person from approaching the court?
At that relevant point of time, yes, lordship, legal aid was not provided.
Aid may not be provided, but did anybody prevent you from coming to the court?
Because that was from his family also has to come. So no one supported him to come approach this honorable court. So he, after coming.
So he had abandoned. So he was abandoned by the family.
So in 2009.
If he was abandoned by the family, possibly he is not a member of the family.
Not abandoned, his children are there, so who will fight for them, for him? Reason is that financial constraint was also their lordship. That plea also is being taken here.
So the manner they approach Madam Ghosh for filing the IA to condone, same way Madam Ghosh could have been approached 3 years earlier also. The petition would have been in time. So he took 3 years to have the message that
Then COVID was there, lordship.
COVID.
COVID was there and his documents also, he got the documents because in 2019, 28 December, he was released from the camp. At that time, car protest was also going on across the state, and thereafter, he got all the documents, subsequent documents, voters list of 89 and all other documents. So thereafter, and then.
No, we can, we can, see, we can casually, we can condone it. That in these proceedings, instead of raising this issue, let us condone here you on merit.
Yes, lordship.
But the reason stated,
Yes, lordship.
COVID will not prevent a man for 3 years from approaching the court. COVID may have prevented for 1 or 2 months in between. Number one, if you say that no legal aid is provided, it cannot be a concept in law that unless legal aid is provided, a man will never approach the court. Then you say financial constraint, that for financial constraint, a person for years together will not file. Then if that is the reason, how he became financially well off after 3 years to file the petition? Your answer will be, I am doing it pro bono. If he were doing it pro bono, he can find a lawyer who is doing pro bono after 3 years. What prevented him from finding a same lawyer 3 years earlier? So therefore, we are having difficulty in accepting the reasons, because moment we accept this reason, this will become the set pattern of the law. But if Mr. Paying, therefore we put it on Mr. Paying, but if Mr. Paying without objecting allows the delay to be condoned, it will not be condoned because of the reasons given, but it will be condoned on the basis of it being not objected. So you can take a look at Mr. Paying, what he says. You can ask him what he says. Show it. It says that without any reason it can be condoned.
Cause is sufficient. Cause has to be there.
This is where we are having difficulty. If we accept all the 3 or 4 reasons you have given, saying them to be good ground to condone a delay of 3 years, then that will become the law. Number one, as there is COVID for 3 years, don't worry about delay. As because legal aid was not available, don't worry about delay. As because a person is having financial difficulties, don't worry about delay for 3 years. These will all become principles of law. Have you understood why we are putting this question? But if the state does not object to it, that let it be heard on merit, we can pass the order. Then it will be not because of these reasons, but because of non-objection. Therefore, I said you can take a look at Mr. Paying. You are yet to take a look at him. Three years we can, but still 2 years remain. 2 years of a ground over. No, I can do minus the COVID. But we get a ground, we get a ground. What is the outcome of looking that size?
Well, COVID period, it can be accepted.
Sorry,
For
no,
COVID.
instead of fine. Normally, we are also a little liberal in this thing. Difficulty is, if these reasons are judicially pronounced that these reasons are good reasons, tomorrow it will become the law.
Yes, definitely.
This will become a precedent.
Well, not, if it is a case of 1 and 2, it's okay. It's no matter. We have no.
No, but
objection.
at the same time, just because a person did not come for 3 years, will you send him across the border?
That is, but the decision of this honorable court is there.
So why don't we do one thing? We keep the limitation open, here is the review on merit. If there is a good ground on merit to interfere,
In the review.
that we make it a reason to condone the delay and condone it and allow it to go. And if you find on merit, in other words,
Yes, let it be, my lord, let it be.
in other words, indirectly it is condoned, impliedly it is condoned, although not expressly.
Then that can be done, man.
But otherwise, we are apprehensive because if this is a ground, and not only in a foreign tribunal, tomorrow
In some other.
this will be taken in every situation. So 3 years will be just a figure. All that a litigant is required to say, COVID, there is no legal aid available for me. Financially, I had difficulty. And what is the fourth one you said? Add that one. So all these 4 reasons will become the law tomorrow for condoning any kind of petition anywhere. Especially those highly contested civil cases, they'll come and take the same stand. There's no difference between a foreigner's case and a civil case as regards ground for condoning. Nothing. Citizenship is a concern of one individual person and nobody else's. There is no public interest in it to make it an exception. It's the interest of one person. One person only. In this case, there are absolutely no public interest. It's a personal interest of one person. That's all.
The person will be stateless then, because why the
The
other
per-
state?
Every person will have to face the consequence of law. The consequence is bad. That's why not face it is not a reason.
After coming, because he was in detention, thereafter-
Doesn't matter. Unless you show material that when a man is in detention, he's prevented from going to the court by somebody. No one is preventing.
Subsequently, I got the document. So I-
That will be your basis for merit in the review,
Yes.
not for condoning the delay. Think over. Adjourn on the prayer of the parties. To be listed on so and so. On the issue under which ground the delay is required to be condoned.
Item 34.
Because Mr. Payne, there are some Supreme Court judgments where delay is condoned because of a strong merit in the
Yes.
correspondence. bring at least one or two such judgments. There are few judgments on condoning delay, which is directly linked up to the merit of the claim.
There is no state jacket formula in this particular hearing.
Sorry.
There is no state jacket formula. Honorable Apex Court has held that in this particular judgment which I have given today, there is no state jacket formula.
But also there has,
Approach.
even near the most liberal approach, accepting a ground becomes the law. So then, or you think about a ground which will be acceptable in law.
Acceptable ground that can be.
Think about it. We allow you to bring in more grounds also if you want. But that will be a dangerous precedent if I accept these grounds.
34.
34 is some
Modification of what?
No, not modification, just extension of time. Modification with that extent.
By the order dated 2/6/2023 in WPC 3269/2019, the writ petitioner Phul Khatun was required to appear before the tribunal on 10/7/2023 for the reasons stated in the interlocutory application. The applicant could not appear on 10/7/2023 and therefore has instituted this interlocutory application for extension of the time. Reasons given in the interlocutory accepted. The petitioner, the applicant petitioner to now appear before the which tribunal? Foreigners Tribunal. The foreign tribunal number 1 Borpeta on at a date of the
30th August.
30th. The all other terms and condition of the order dated 2/6/2023 in WBC 3269/2023 remains as it was provided earlier.
35.
Yes. Yes, Mr. You are Hawk and Hawk.
Page 13.
Page 13. What is page 13?
Second paragraph. Further correction of the order dated to the in the line 13, the name of the mother, the word mother have been very much. Name of the mother of the
Mr. Counsel, when you dictate the order, please be a little more careful and listen also. Most of the time when we are dictating the order, your thought is somewhere else. As if my work is over, I have argued the matter. Point it out. These facts are not more known to you than to us. Other time, you concentrated more in the name of Suburjan instead of Sukurjan. We passed that order. Well, whether Suburjan is the mother or grandmother, you are not required to look that meticulously. It is for you to point out. How does it look? Correction after correction. And firstly, this thing should have been pointed out in the original order itself. The role of the learned counsel is not over till the order is dictated to the complete. Only thing we require you not to disturb in the middle of the order. But you can always point out at the end that it is Sukurjan, not Suburjan. Point out, it will be corrected. It is mother, not grandmother. Point it out. Instead of filing repeat correction petitions. Third, Mr. Enoch. In the order dated 28/4/2023 in 36/2023, in IS Civil 166-2023, in the second penultimate paragraph, Tuburjan be read to be the grandmother of the petitioner and not mother. I allow so the aforesaid correction.
36.
এই একটা order লিখি দিব order এই আগৰটো যেনেকে হল order dated 26/5/2023 WPC 2948/2023 the 15 days time granted to the applicant petitioner to appear before the Superintendent of Police border from the date of the order, that is 26/5/2023, is extended on the prayer of the applicant. And now the petitioner shall appear before the Superintendent of border within a period of 15 days from today, that is as it did. I allow subject to the aforesaid correction, and all other terms of the order dated shall remain as it exists.
37.
Extension. You have 15 days or fixed date. Earlier, what was provided? We don't want to open this file.
It was fixed.
Fixed date. তেতিয়াহলে আগৰটো নিচিনা। আৰু যদি 15 days, one like the later one, the same order. Yes, next one.
38. What did you?
15 days or fixed date? Like fixed date order. Data that the
Item 39. Fixed date, maybe. Please, August.
Yes. Fixed date or 15 days? 15 days to marry people.
Item
15
40
days
for
from today, as it date.
item 40 for hearing.
Lordship, in this case, directed us to verify the voter list of 1970 and 77, your Lordship. 79, sorry. Yes, sir.
There is some time to produce a 77 required by the order of so and so.
The certified copy is telling with the original, your Lordship. And the name of the petitioner's father.
The voters list as required by the order of 15/6/2023 is made available by Mr. A. Ali, adjourned to be listed and so and so. The voter list may be examined by the Council for the Home Department.
38 August. Item 41 for admission.
Your Lordship, yesterday the first and the foremost question which was posed upon me was the maintainability.
Maintainability of what?
Maintainability of writ. And maintainability of writ during the time of investigation. A very recent
Police.
judgment which was passed by the
Change to police.
Supreme Court in the month of April this year also.
Lordship.
It's a Ritu Chabaria's case.
Yes, Madam Sharma.
Lordship, there are ample judgments, but my senior, Mr. D. Nath, he is in the hospital because of his mother's ailment.
Hospital.
Yes, Lordship.
Adjourned.
He'll be coming soon.
But also I
But
have the urgency.
the matter may be taken up after some.
The medical urgency of a council cannot be brushed aside. And we are bound to give him a hearing. It is stated that there is a medical emergency in respect of the murder of the learned senior advocate, Mr. D. Nath, and therefore the land council is inconvenienced today. Please come, take fixed date. Monday get time.
Next.
Monday.
But his lordship is saying something different.
This judgment has been stayed by the Supreme Court itself. Need to subject it by another bench.
Stay course.
Stay, it has been.
Yes,
stayed.
yes, yes.
But we are not aware of
It is a
So
controversial.
you have been made aware.
because one of my senior
Right.
appeared in this.
You may not be aware, but you have been made aware.
But even though if Ridus Chabaria's case aside, then again the Godrej Sarali Limited comes into place. Which
What
says
is-
the maintainability of.
What is Godrej Sarali?
It is a civil appeal. Messrs. Godrej Sarali.
Civil
Limited was-
appeal.
Yes, where the Supreme Court specifically said the maintainability of writ. Under
No.
26 and 30.
Maintainability of a writ petition in general and maintainability of the writ petition in particular in a matter where certain investigation is under challenge, they will be different.
Even-
The general law cannot be made applicable in a specific case
Yes. Your
when
Lordship, but-
the law in the specific case is different.
But your lordship in Aditya Begum versus the state of Maharashtra, then in Subramaniam Swamy versus CBI, the Supreme Court specifically says the victim has a right to claim for fair investigation. So that is also there. And
Lordship,
even if we keep all this judgment aside,
What materials are available for us to
There is a difference between fair investigation
unfair.
and where investigation is being initiated, but you feel that investigation is not going on.
but
Fair means something is going on, but they are doing something unfair. Just a minute. And investigation not going on means it's not going on in the desired manner.
now your lordship, there are two aspects.
Two
Of this case. of
two
this
aspects.
matter.
Okay, what are the two aspects?
The fair investigation is subjected to the criteria under the equilibrium jurisprudence.
What is equilibrium jurisprudence now?
Jurisprudence where the equality is not to be discriminated along with the other categories.
So are you trying to make out a case that because of your status, you had been discriminated?
Yes,
Is that your case?
yes.
Okay, we'll hear you, don't worry.
And
If it is your case that because of your status you are being discriminated, of course, you'll have to look into that.
yes, that is the first aspect. Second thing, the section which are imposed in that FIR are all bailable section. Now, as per the Rakesh Kumar Pal judgments, the quantum of punishment where the punishment is less than 7 years, the investigation period is 60 days. So in here, the affidavit which has been filed by the officer in charge stated that the investigation is still on.
Affidavit where?
Affidavit in opposition.
In this writ petition?
Yes.
Acha, here it has gone to the stage of affidavit also.
Yes.
I thought it was on motion yesterday. Notice had already been issued.
Yes.
Lordship, we have received the case diaries
Oh,
also.
yeah, notice is issued, right? You are right. Hmm. So we are hearing the matter then.
Yes. And fix for final hearing. And in the meanwhile, your lordship, there is no difficulty to transfer the case from Jalukbari to Alumni.
That is the final order. How can it be an interim order? But one case we are taking note of, one of your submission. that the authorities, while investigating because of your status, they're discriminating. That will definitely look into. Because it too,
The other aspect.
that requires.
The other aspect, Your Lordship, even though if we look aside, keep aside my gender and my status. Even for any particular case, whether she is a victim, the category she, I'm referring, it may be anyone. She may be a victim, she may be accused. But for the compulsory requirement of a medical, then after the sunset and before the sunset, and woman is required to be set in the entire police station during the overnight. That is subject of
Do you have the, Madam Sharma, do you have the GD entry?
Yes, Lordship.
We have the GD entry. Let us take a look. GD entry to log on, right? How long the person was kept in police custody. A two question to look. No, police custody, like you won't worry.
Lordship, 2 case diaries have been sought for 1 Jan. One is Jalukbari, one is all women.
Where is the GD entry? This is the city, GD.
Then এখানে প্রযোগটা আপনি যাও এখানে প্রযোগ এক লাইন কথা প্রযোগ দেরি হয়ে যাবে নাহলে
On which day were taken to police custody? On which day you were taken to police custody? So you said that you were kept in the.
police custody for the requirement of medical.
No, you said that, yeah, no, I remember yesterday you said that you were kept in the police station all through the night.
What I said is for the medical requirement, I was kept.
Where?
Entire
Where?
I was taken at 12 o'clock.
Uh,
Some Papa party.
Forget about your papa and all. On which day, what time you were taken?
16.
On,
At night, 16.
on,
11.
just a minute, night on 16/5/2023 at 11 AM,
Yes,
you were
11
taken,
PM
11 PM, you were taken for some medical checkup.
for medical.
Where were you taken?
Ayurvedic Medical College. Jalukbari.
Ayurvedic Medical College, Jalukbari. And you were kept in the hospital overnight.
No, not in the hospital.
Where?
After the preliminary checkup, I was being taken back to the police station.
That's what I'm asking. And what time you reached the police station?
After 1 or 2 hours.
After 1 or 2 hours, after being taken at 11 o'clock, you reached the police station. After that, what happened?
After that, I was was sit there and they.
You were kept in the police station.
Yes.
And this is the information we're
Yes,
asking.
and they-
Have you stated it in your writ petition?
And at
Just a
17
minute. Have you stated this information in the writ petition? In which paragraph? And it will offend me over this part. Where have you stated this fact in your writ petition? That at 11 AM on 16/5/2023, you were taken for medical checkup to Ayurvedic College. After examination of 1 or 2 hours, you were brought back to the police station, kept there overnight. Where is that statement? Where is that statement?
that statement is not here in the.
But
report.
it's it may not be, but if it's,
But we will file our affidavit in reply in that. Because, Your
Hmm.
Honor,
have you stated that in your affidavit in reply?
no, we haven't filed yet.
File it.
Yes, that we will file because.
The petitioner in person, Swati Bidhan Borua, praised for an adjournment to file an affidavit, bringing on record the fact as to on which date, at what time the person was taken for medical checkup to the Ayurvedic College Hospital, and at what time she was brought back from the hospital to the police station and kept in the police station up to what time thereafter.
Because
File it by tomorrow, we'll take it next week.
tomorrow is Saturday. Don't know whether it's.
Natalie was.
File it on Monday. Monday you file it, we'll get a list. On Monday open now. We're listing on 21st. We're listing on 21st.
Your Lordship, 21st I will be here.
Sorry,
21st I will be here.
22nd.
22nd. 22nd.
And before that, you file your affidavit.
Because
And once the affidavit is filed,
Lordship,
we expect a reply from the state also, from the
Lordship.
police.
we'll
Uh,
place
the-
certain judgments.
List on so the required affidavit be filed or no before next week or at a date D20.
18th,
Before-
17th.
Before 17/8, you file your affidavit on or before 17/8. And once the affidavit is filed, the state authorities, if so advised, may submit their reply affidavit. List from so and so.
One second. I'm not saying anything. Only thing is,
Do you know what is the duration of time in a second? 1 second
it's
is
finished.
enough to say you call it to be 1 second. Thereafter, you have no further time.
Only just one.
1 minute now. Okay.
Just one line and I will finish. Even during this medical checkup, they took me to the Ayurvedic Medical College, which is adjacent to Guwahati University, approx 3 kilometers from the Jalukbari police station. Whereas the Pandu FRU is there, which is approx only 200 or 300 kilometers from my house. They didn't took me to the Pandu FRU, they took me at the night to the Ayurvedic Medical College. There are certain lapses. I will.
How you were taken by some papa vehicle?
Yes, some Papa vehicle. I don't know what they say, what they quote that vehicle as Papa. I don't, the Papa Tina.
Some word, I think. Yeah, meaning এটা আছে।
Petroling.
আগতে আছিলে এই গাড়ীখনত কিবা লিখা থাকে Papa 1, Papa 2 ঘূৰি ফুৰে। Ghosh, any idea what is this Papa means? No, in fact, we have also noticed vehicles moving around in the road. Papa 1, Papa 2, it's written there in large thing. Must be having some technical term. Some police vehicle it is.
Yeah.
So you have gone in that vehicle, Ayurvedic, brought
Yes,
back to
it
the
was
police
surrounded
station?
by all
And at
vehicles.
what time you were released from the police station?
I was released at approx 3 or 4, 3:30 or 4.
3:34 in the night.
Yes, in the night.
You filed your affidavit.
Because when they were taking me to with the for a medical, no woman was there. I was surrounded by male constables.
মিলাই দিব বস্তু আইটেম 14 টু কি হইছে এটা লেখানো আছে কোনে পাইছে এগুলা কত করে লেখাই না এগুলা লিখি দিও কোনো এটাও লেখা নাই August 30 August এটা লিখি দিও
It's okay. Also, in general investigation.
You file your affidavit, you also give your reply on 21st, we'll hear this issue.
22nd
22nd of
Not 22nd, we'll hear this issue. And what are your other reliefs you are seeking other than this aspect?
The first preliminary relief that we want is transfer this immediately.
No,
to-
transfer is not just for asking normally, because we have to go by the law.
Yes.
Mhm.
And second one is take necessary disciplinary actions on the defaulting officials.
Acha, whosoever is the police official responsible for this conduct, they should proceed against them. These are the two basic prayers. Transfer, we'll see, we'll have to see to what extent the High Court can do, under what circumstance it can be done, we'll have to examine that. Regarding this issue, we'll take it up a little separately.
Your Lordship, this is a clear violation of what the NALSA says and what the Swami judgment talks about.
And we don't remember so many names like Nalsa and Putswami and all. We have to produce it before us and then say,
Yes, sure.
if you want to rely on any specific proposition of law later on, you just produce it before us. We'll definitely take a look at it. So file your affidavit, we'll hear you on.
Obliged.
Yeah, just a minute. Oh, you do know. Oh, not your matter, some other matter. Sorry.
Item 42 for orders.
42 things here, extended.
Order.
42, what is it? Here,
Order.
HRA Chaudhary.
Belmar.
None appears, list again. Or again, again.
Right.
Okay.
Modification.